What are the most crucial arrangements, agreements, policies that all organizations must have?
Okay, so the first question, though they are basically uniform, but then again, while drafting your employment handbook or drafting your contract, the aspect that one needs to consider is for whom are you drafting it? Is it for a person who's at an executive level? Is it a standard format? Are you drafting for all the employees or less? So, for example, if you are majorly in law, first I like to tell you there's a category of workmen and non-workmen. So when you're drafting for workmen, the laws are different. You need to take into different policies into account, and for employment agreement into account, and for handbook, again different factors would come into play. So the main thing right now we tell our clients is with respect to sexual harassment, it's a very important policy in terms of employment handbook. The second, there are other policies you are required to have in your company which not many people are aware of. But then again, if you're an MNC, if you're anyway related to a US company or a UK company, there are certain anti-corruption policies that you're required to have. As a part, if you're an IT company, you're part of an e-commerce group or you're collecting information online, then you need to have a data protection laws as such. So again, if you're anyway connected to a US organization, you have a parent company which is a US organization, that happens with a lot of our clients, then we're required to have a whistleblower policy. But these are just the mandatory compliances under the law. When you're drafting an employment handbook, the most essential part is your leave policies. Again, how these leaves have to be determined, again, we have to go back to a Shops and Establishment Act, which is there in every state. Every state is governed by its own Shops and Establishment Act. So that has to be looked into account. Those have to be taken into account while drafting. So as I go, as I'll discuss further, I can go further and discuss it, but you can be more particular with your questions in that regard. So right now, do you want me to speak about the employment agreement first or the employee handbook? So, with respect to employment agreements, okay, so in employment agreement drafting, so first, as I said, we need to determine for whom are you drafting it. Are you drafting it for executive level person? Are you drafting for a non-executive level, like a normal standard workman? Or someone who will be reported by. So first you need to have a designation of that person in place. You need to explain who will be reporting to, who's engaging him, which is the company, what position he will be hired at. These are very important. So appointment, acceptance would be there as well. Then what's the nature of his employment would be the second thing that needs to go into the drafting. So that would be whether that person is a permanent, or what is his probation period, for how long he would be engaged by the company. Will he be a contractual employee? Is there a fixed term? So that is the second aspect that needs to come into the employment agreement. The third is more about his job description. What is the nature of work? What is really expected out of him to do? In what capacity he's being hired? What role he's being offered? The fourth would be the remuneration. With respect to his salary, you need to tell what his salary is, what all privileges he will be given under, along with his salary, what all perquisite bonuses will he be given. So something like PF, though mandatory to all employees, not all, after a certain limit, it becomes a voluntary thing. So if your company is giving you PF or any other perquisites, you need incentives, you need to take that into account. And with this also a clause with respect to deduction goes. So all employees are required to know that a TDS is deducted from their salary on monthly basis. So it is better to have it in the agreement. The third would be any terms of payment that you may have, like when would be the salary paid? Monthly, mostly it is monthly. We don't have any other concept in India. So that deduction we have covered. Then we come to the nature of work and how it will be done. So that would cover the working hours, the timings, the leaves, the holidays, conditions of any leave that you may have. All of that would be covered in. And then we'll come to other aspects, which would include confidentiality, non-disclosure, Confidentiality, non-disclosure are very important. They're separately covered in agreements. We at times have a separate agreement with our employees, depending upon what level he's being hired or depending upon what kind of industry you're involved in. See, it depends industry to industry. If you are in a manufacturing industry, signing a non-disclosure or a confidentiality agreement is not so important with your employee. But if you are somewhere related to technology or anywhere you where information or service industry where information is really important, you have to sign a confidential. You should sign a confidentiality and a non-disclosure agreement with your employee, because then that is your asset, and a lot of mess can be created if those clauses are not there, and later you could be facing a lot of losses because of diversion of information and all that. So they are very important for any organization relating to service industry or IT industry to have. I think I'll speak separately on these two clauses again. Then again, IT, intellectual, non-disclosure will all go together. IP is also a very important clause to have in your employment agreement, especially we're dealing with information which includes your intellectually protected property. Then you come to other aspects of termination. Termination, very important again, but I would like to let you know that most of the legislations in India require the employer to give 1 month notice, and the employee in also to give 1 month notice before resignation. But what happens is a lot of employers tend to bargain it in a manner where they have more leverage over the employee. Like they would require you to give 2 months notice before resignation, and they would require you to give 1 month. They would require themselves to give you a 1 month notice in lieu of salary. So there's a lot of controversies. There's a lot of cases with respect to these clauses which happen, so they have to be drafted very carefully. One, the timing of probation also have to be taken into account. If you terminate an employee during probation, is there a law restricting you? Because every state have different laws on probations. The probation period is different, so that needs to be taken into account. Termination, again, it is better to have a reasonable clause. Otherwise, if you have a very one-sided clause as an employer, then it is not seen good in the court. But at time for deterrence, you have it. Like for example, if you see most of the airlines, they have clauses where the employee is supposed to give them 3 to 4 months of notice, which is a huge liability, and they're required to pay also if they're not able to give that notice. The courts, though the courts do not recognize it, the courts will not give damages beyond a year, but you as an employer can have such clauses as a deterrent, because a lot of industries require their employees to stay or give them a good notice, so there's a very smooth takeover. So again, as a deterrent you can have it, but the implementation is very difficult. Then you come to non-compete. Again, it is a lot of cases have happened. They've been challenged. So non-compete clause is where you restrict the employment of your employees post termination in any other business which is similar to yours, any competing business. But the courts have not upheld this clause. The courts have gone ahead and said that any negative covenant after the terms or after the your employment is void in terms of Section 27 of the Contract Act, because they would restrict on your livelihood. So there are many famous cases in that. I can discuss that in further when I discuss these clauses separately. So again, they avoid, but again, companies have it. Big companies have it. Like it's a conscious decision where companies decide to have this clause in their agreement, because again, as a deterrent. Because employees, not all employees know the law. You as an employer would know. Non-solicitation, very important. Non-solicitation and confidentiality clause are to an extent enforceable. To the extent they are reasonable, are enforceable in the court. So you should have them, and it is very important to protect. Non-solicitation is where you stop an employee from poaching after termination, poaching your employees or using in on confidentiality. Confidentiality would be where you want to stop employee using trade secrets or information which he has acquired in his employment with you after termination. So these are important clauses for any employer to have in the agreement. But how effective they are would depend upon how nicely they are drafted, whether they are reasonable or not. Only reasonable clauses are taken into account by the courts for enforcement. But remember that you need to have a relative clause for damages. Unless you have a clause for damages with respect to these language which includes damages, then they cannot be enforceable. So for any non-solicitation clause, you should also add any damages that the employee will be liable to pay to the company in case this provision is breached. Same for confidentiality as well. So we've come to non-compete, confidentiality, non-solicitation, and there's another this clause, non-disparagement. Again, not many employment company contracts have it, and I'm disappointed to see that, because there are a lot of cases where an employee, after the termination or after being terminated from a job, likes to speak a lot of ill about that company, and especially where big companies involved, there's reputation at stake, and especially with the media at our at such a accessibility of media that we have, these things can really go viral. Like we also Cyrus Mistry going after Tatas. It did them a lot of harm. So is there a clause, it is important to ask, is there a clause in the employment agreement where the employer can stop an employee or have him pay for the damages for any loss of reputation due to such statements being made by the employer? So there have been cases, especially abroad, where a Yahoo ex-employee CEO had to pay like $10 million for the damages. So it is very important to have such clauses. Then coming to a clause which refers to your company policy. All employment contracts need to bind the employee to the company policy as well. So somewhere employment contract is a bigger is definitely the terms which govern one's employment. But again, we need to understand there are a set of company policies also which will also always govern employee. So to bind them, in addition to these terms, you need to have a clause in your agreement. Also, you need to have a clause with respect to amendment, with respect to your employment contract or any company policy in future. So there has to be a separate clause for amendment, which recognizes the right of the employer to have an amendment unilaterally or mutually at any future date, or to have the right to amend the company policy as and when required. Because again, these issues, if not taken care at the time of drafting, becomes very big at a later stage, because in the labor laws, the employer cannot change terms of employment that easily. So that is why you're required to have consent of the employees in each case. So to have this consent through your employment agreement is really important, and it kind of saves you a lot of trouble in the future. Then the governing law, jurisdiction. So jurisdiction is generally the governing law, and the jurisdiction is place where you're located, your workplace. Um, some may talk about arbitration as a clause for resolving disputes with your employer. I will not recommend it in most of the cases. Arbitration is only used in cases where there are disputes with the higher level of management, like CEOs. Otherwise, it's too expensive to have it in your employment agreement. The courts, the labor courts can address these issues, so it is not so much of a problem. So these are the major clauses that you should have in an employment agreement. If anyone has any particular clause that they want me to speak in length about or to explain, I'll be happy to do that.
Thank you so much, Devika. Can you please illustrate on how IP laws are drafted? Like how to ensure that all the IP created by employees are not infringing third parties' right?
See, when you are drafting a IP law or a intellectual property, confidentiality, and any of these laws, IP law, sorry, I'll talk about the IP law first. So what happens is, when you're contracting with respect to infringement from a third party is not so much of a concern of the employer. The employer wants that all the IP that is created while a person is working with him are duly assigned to the employer and not to the employee, which is the general norm. But again, the employees also need to be concerned about any IP that he particularly brings, or any intellectual from himself to the company. So again, it differs from industry to industry. For example, in IT companies, they are required, all these codes and everything that is written are patentable, and they have copyrights in them. So who in whom is this right vested? So obviously the employer in most of these cases is the one who's assigned these rights, and the employee, by the means of this employment agreement, agrees to assign any IP created by him to the employer. So this is one. With respect to any third party, again, the employer as such will be infringing a third party IP only when the employee is bringing some information from his previous job, or any information that is previously acquired by him that doesn't belong to him. The company cannot really have any kind of control over it, but of course they can have a clause which takes acknowledgement from the employee that he will not be using any such information where the other party has a copyright in the employment, during his employment. So that's the only way you can have a protective right, but there is nothing to really enforce it.
Can you also illustrate upon non-compete clauses? Like how does that work for a consultant or for somebody maybe who is freelancing?
Exactly. So, as I said, when you're drafting a employment contract, you need to really understand now for whom are you drafting. So, employment contract for service and contract of service are very two different things. So, I'm taking you back to the basics. I'm sorry, I'll really have to elaborate on that. So, when you contract for service is for an independent contractor, where the person is not engaged, you're not paying any social security payment for him. He's an independent person on a retainer. So for their non-competes are very important, and you can have it. But again, the courts have maintained that you can have a non-compete only till that person is working with you. Though having such non-compete in case of a contractor is not held in a very positive light by the court, even during the time of employment, because of course you're a freelancer, then you are working with same kind of people. You are a service provider, you are an independent contractor, then an employee. So your status changes. Not just your status, your tax liability and everything changes. Okay, so that is why non-compete does not hold so much good with respect to independent contractor. Of course, you can have a non-compete with respect to your present employee. So that is why whenever a lot of times we have queries from companies who want to retain certain employees of theirs as a independent contractor. That could be for the purposes of tax, saving tax. That could be for the purposes of having a part-time employee. So we always advise them, then it's okay to have such a clause, such an arrangement. You can do it under the law, but something like a non-compete, confidentiality, all have to be really taken into account, because the courts have taken very different view with respect to contract for service and contract of service for independent contractor versus the employee. The effectiveness of the clause varies.
Thank you, Devika. Moving further, how can organizations prevent disclosure of IP and confidential information of past employees?
See, again, as I was describing, non-disparagement confidentiality agreements and non-disclosure agreement, they have to be connected. The only way the courts have recognized these, they are recognized even post your employment, but then they have to be linked to your damages. The only way you can stop a person in practical, but you can ask a court to stop a person from divulging this information is through asking for damages, and you have to prove those damages. It becomes very difficult, but it is, again, these clauses are a very big deterrent, as well as can be implemented if you're proven rightly. So you have a clause where you limit any information, and you say that any such information would cause irreparable damage, and that damage may be unaccounted for, but nevertheless the employee agrees that such a damage will happen, and he acknowledges to give pay for it. So you need to have this kind of clause in your non-disclosure or any confidentiality clause, because there have been cases like you have a Daljeet Titus case where um, a lawyer who broke away from his firm took a lot of confidential information and clients along with him, which to which it was challenged before the court. The court said that they can only stop him. They can. There's no injunctive right as such that can be given, but yes, damages with respect to information that has been divulged and proven before the court can be granted.
Thank you, Devika. Moving further, how are gardening leave provisions drafted?
Again, gardening leave provision. I'll explain you about this provision a bit. The gardening leave is when you are paying an employee after the period of termination, or at the time he's given the notice, his pay, and asking him not to, in lieu of that pay, not to engage with any other competitor or employer. Again, this is by the courts, and there's one Bombay High Court judgment in this, which is their view in this matter has been that gardening leaves are a negative covenant, and especially not recognized after the termination of employment. So while drafting this clause, one needs to take into this account that they are not enforceable. So if you have anyone to breach it, you can't really do anything about it. But yes, again, as a deterrent, a lot of companies have it. So while drafting, one should make sure that it is better to have a gardening leave provision at the time of notice, as against having it post-employment. Gardening leave is a concept which may be recognized in UK and US, but not in India. So though a lot of templates can be drawn from there, we can have similar provisions, but again, not enforceable. So better to have it during the notice period than having it post termination.
Ajay, Devika, moving further. Now, generally, when someone is offered an executive position at a firm, the contract will often include a golden parachute clause.
Yes.
So, can you please illustrate upon what is this golden parachute clause and how organizations should draft these clause?
So a golden parachute clause. A golden parachute clause is generally where a person in an executive level or a higher management is offer a lot of incentives for being thrown out of that company. So in what scenarios that is actually it happens is where a big company is a company is being taken over by another company. There's a change in control, and the CEO or the main management of the company has to be misplaced. So instead of doing it with a lot of hostility, what companies like to do is give them incentives to move away or step down from the board or from their position. So, for example, when Motorola was being acquired by Google, they gave the same parachute clause or the incentives to the then CEO of Motorola to step down from his position, because again there's a change in control, and different people would come into the management vis-a-vis your connection with the acquirer. So that is one. So while drafting it, it's mostly done in way of ESOPs or in way of as a compensation. You must remember that when you're drafting this agreement, you are asking the employee to waive away any right that he may have with respect to any litigation from termination, with respect to termination. So this is one line that should definitely be a part of your golden parachute clause.
Next question, Devika. Similarly, we also have golden handcuff clauses, right? So,
Yeah.
how are those drafted and how are those different from the golden parachute clause?
So, as against golden parachute clause, where you are giving incentive to an employee to leave the organization, golden handcuff clause is where you give incentives to an employee to be in the organization. So, incentives can come in a lot of forms. incentives can be in the form of ESOPs. So ESOPs is giving equity to your employees, equity on a future date if they have completed a certain. Generally, it is when a certain employees has completed a certain duration in the employee. It could also be in form of bonuses, huge amount of bonuses, or you could have bonuses after 2 years. The other form of having it is giving a share in the net sales. It is a very common clause you may see in case of marketing and sale employees, where they have point some percent of the net sales of the company. They are used heavily by the startups. They're used heavily by the companies who have to compete regularly because they are fighting for a good mind, a good intellectual mind, and a good asset, where employees are asset, big assets. So again, service companies as well. So that is where they have this clause in form of ESOP, bonuses, any other incentive in their agreement to retain employees. So while drafting, you have to look into what kind of policy that you're having. So for ESOPs, are you having different policy for all the employees? Is it the same? Is it under a scheme? Is it floated by a listed company, non-listed company? All those have to be looked into. A lot of time, nowadays company subsidiary in India is allowed now to give ESOPs, to offer ESOPs to its employee for its parent company in US. Now the RBI allows it. So it is also seen as a big parachute, not sorry, the golden handcuff clause in the agreement to help retain the employees, because no one wants to go through the whole high attrition rate. It really costs a lot to the companies.
Moving further, Devika, how is a leave policy drafted? Like, what are the important things one should keep in mind while drafting a leave policy?
So again, there is a lot of to and fro's. There are a lot of queries with respect to leave policies. It is most simple thing, but we get a lot of queries with respect to that from our clients. Leave policies have to be in consonance with your Shops and Establishment Act. Or if you're a factory, then it has to be in consonance with your Factory or Standing Orders Act. So that has to be taken a note of, that what category your employees fall in and what leave policy. Mostly it is Shops and Establishment Act because they have upper limit. So you need, so in case that you have leaves, a certain stipulated leaves under Factories Act, and you have certain stipulated leaves under the Shops and Establishment Act. And if Shops and Establishment Act entitles an employee more leaves in your state, sorry, you have to give a whatever leave prescribed in the Shops and Establishment Act. So, for example, in Karnataka, if the Shops and Establishment Act entitles an employee to have 18 privileged leaves, then you can't provide 15. You have to provide minimum of 18 privileged leaves. Mostly, all states have leaves divided into privileged leave, casual leave, sick leave. Some states have a mix of casual and sick leave. So I've seen a lot of companies in a practice, what they do is they provide privileged leaves to their employees in their employment contract, but they forget to to give casual and sick leaves. It is against the law. If you're not providing, you can be dragged to the labor courts for it, and you can be asked to pay penalty for it as well. So that is why it is important that you, whatever leaves that you're providing are in compliance with the prevalent laws in your state. You can give over and above what is the limit provided in the act, but not less than it. A lot of time we have companies which have offices across India. So in such cases, you have different laws applying to their different branches in each state. So in such cases, either you can have a uniform policy which has the upper limit of all the leaves that you are entitled to in each state, different policy for each state. So that, and also you need to take into account that leave policies needs to include the leaves that can be accumulated and taken forward. Again, there is a clause in each state that entitles an employee to take forward certain number of leaves. So you need to have that provision in your policies. And second, encashment. Well, how much of those leaves can be actually encashed if not aware by the employee?
Alright, Devika, moving further, how are companies supposed to draft their anti-sexual harassment policies?
Okay.
What are the important clauses and how should they go about it?
So with sexual harassment law coming out in 2013, we see that not a lot of companies are still complying. 90% of the companies are not complying. But with the law coming to the forefront, every company is required to have a anti-sexual harassment policy for women in their workplace. They need to have this policy for women, but we'll get a lot of queries about it. Can such policy be extended to men? So, what view the industry has taken? Yes, it can be. You can have a general sexual harassment, anti-sexual harassment policy for women and men, because the law mandates you to have it for the female. You can extend it up to the men. What policy should include? It should definitely include what certain provisions that are under the law, which will include what is sexual harassment. The definition of sexual harassment is actually given under the act, but you can elaborate them. You need to have that. You need to have a clause provision with respect to constitution of ICC. The procedure for inquiry. Um, Again, the procedure of inquiry is very vast and explained, so you need to elaborate upon that. You need to tell your employees who all are covered in it, who all would be covered, who for against who all such a complaint can be filed with the ICC. ICC, the Internal Complaint Committee. Sorry, I didn't tell you. So all organizations are supposed to constitute an internal complaints committee under the Sexual Harassment Act. So it is better that such constitution of the committee is covered under your policy. Then investigation, inquiry, recommendation, and then implementation, and the most important is penalties. You need to have a clause of penalties detailing that what penalties you can have. There are certain penalties that is suggested in the act, but you may have penalties over and above, but I think it's a pretty exhaustive list. And second, yes, you need to have a provision for conciliation. There's a clause for conciliation where the female employee can, before going for an investigation, have the matter conciliated. So that should be included. There should be a provision for malicious prosecution, malicious complaint. So we see a lot of times that the complaint for sexual harassment can be malicious as well. So in case it's malicious, the female can will have to bear the same penalties as men. So you need to have a provision. Most importantly, which is not there in the law, you should have an anti-retaliation clause in your sexual harassment policy. A lot of time we see that a victim is further victimized in a company because they don't have an anti-retaliation policy. So it is good to have such a clause, especially when such cases go to the court. It is good to have a policy. And another thing that we really recommend our clients is to give out the details, name and number of the ICC in the policy itself, because the law requires the policy to be well circulated. It requires the name of the ICC members to be known to all the employees. So if you circulate it along with the policy, then somewhere you can also draw an acknowledgement from them that they have read and they do have the knowledge of the person who all are there in the ICC committee. Uh, Again, sexual harassment policy is can go into lengths and lengths. You can describe about a role of each individual and how behavior, but it's a very broad and elaborate subject altogether.
Thank you, Devika. Moving further, how is code of conduct drafted? Like we know that every profession has a certain code of conduct. So while drafting an
See,
employment agreement, yeah.
code of conduct, there's certain basic things to all code and conduct. Again, different profession, different, like dress code, which is a part of a code of conduct. A BPO may require employees to dress very casually, but so may not be the case in a service industry where you're interacting with the clients on an everyday basis. Again, rest of code can be very different in a manufacturing unit where you're supposed to wear a certain uniform, or you're supposed to take some precautions in a manufacturing unit. So code of conduct is one of the important things. Open door policy or open sitting policy, where you can require your employees to behave in a certain manner, not speak on phone loudly or not disturb. You can have such policies. Punctuality and attendance can be one where you have provisions where if people are not attending, not reaching office at a certain time, they can be penalized, or the leaves can be deducted in lieu of such late coming. It would also include office decorum, conflict of interest. So code of conduct is majorly covered by these things. When you have a code of conduct, you should also have a disciplinary policy, which is very important. All companies are required to have it, because if you are in future firing an employee because of his misconduct, it needs to be defined under the service rules somewhere. The procedure needs to be elaborated, and there has to be a proper hearing. So it is always important to have a disciplinary policy as well.
Alright, Devika. Moving further, how to draft a termination clause? Like, what are the important essentials one need to keep in mind while drafting the termination clause in an employment agreement?
As I discussed before, you need to be very careful what on what grounds you're terminating and how are you terminating. Grounds, again, they're related to misconduct. So when you're having a disciplinary policy, you have to show a cause for a termination. So if it's a misconduct, it has to be defined in your services. So somewhere to have a misconduct policy or to have defined misconduct is very important. So you can further link it to the termination at a later time. If you're terminating an employee because of performance, then it is very important that you have a performance appraisal system into your policies or into your company. So you can have valid proof while terminating an employee based on his performance. The procedure for termination, as I again said, that the generally, as per the Shops and Establishment Act, all employees are supposed to give 1 month notice for resignation, and all employers are required are also required to give 1 month's notice for termination until it's a case of gross misconduct, as may be defined in your policies. So it is the companies a lot of time have a clause where they can give 2 months, or they can ask the employer to give 3 months in terms of termination. But practically what happens is we always ask our employees to our clients to procure involuntary resignation instead of termination, because termination can lead to a lot of litigation, and generally the courts are very much inclined towards the cause of employees, the workmen. So it is very difficult to prove your case. It is in case you're terminating for misconduct or poor performance, you should have all the valid evidence and correlated documents in place. That will be all.
So, lastly, with respect to the employment agreements, how is an arbitration clause drafted?
As I was explaining when I explained the employment agreement, arbitration is not a very good clause to have it in employment agreement, because it's very expensive procedure. You have arbitration only when involving an employment contract with a very high level executive employee or management level employee. So when you're drafting it, for a client perspective, they would also be the one to appoint the arbitrator. Um, it would be like any other, the dispute would be with respect to termination, but it is not highly recommended.
Also, Devika, while conducting a due diligence, one needs to look into different sectors like corporate matters, labor laws. So, specifically with respect to labor laws, what all important things one need to keep in mind while making a due diligence report? Like how should reps and warranty clause should be made?
So while you're conducting a due diligence, you have to see all the compliances. You have to see there are a lot of labor laws. You have to look at the particular state labor laws, if all the filing and reporting, the statutory registers have been maintained, whether they are appropriate policies, whether it's a factory or all workmen are duly covered, whether there's provision for a good maternity policy in your law. Everything has to be seen. Generally, as against maybe the popular notion, the employment law audit is very extensive. To have with respect to reps, having a reps and correlated reps and warranties. A lot of reps and warranties with respect to employment benefit that may be provided by the company, compliances, your employment litigation, having appropriate employment contract is taken from the seller. So it is really important to see that all statutory benefits that you are required to provide are provided. They may be under ESI, payment of bonus, PF, and all those are there in place. And also, if there's a change of control which is affecting the employment terms of your employment, then adequate compensation and the level of the perquisites of employment have to be maintained. So adequate reps and warranties have to be drawn in that aspect as well. And also you have to take whether proper deductions were made as per the law.
Also, with respect to due diligence only, how is inspection of documents and registers done?
So, see now, lately, changes happen. Lot of states like Gujarat and Karnataka, they are having a self-certification of registrations where you're just supposed to certify and there's no such inspection. But as such, there's a format in each state. Every state has a different format, so you need to follow that format while inspecting. You have to compare you during the due diligence. We normally take into account the registers for last 3 years. We have to compare it with the number of employees that are in present or have been at a particular time in the company, and what were the payouts, whether proper incentives were given, what were the wages, were they correctly drawn based on whatever incentive, proper gratuity has been paid, PF has been paid. There are a lot whether a third party contractor was enrolled or not enrolled, contract laborers can know whether they had proper registrations or not. So each law requires you to either have a particular registration, a particular in books in or registers, or to have a particular filing. So again, as per each law that is applicable on that particular industry or organization, a very exhaustive list is drawn by us, where we highlight each and every requirement that is to be made. It's very exhaustive list with respect to all filings, registers, and then inspection is done with respect to every month and every year. Generally, we take 3 years into account. So, but normally what happens is you can a lot of registers are just can be certified by the companies now themselves as per the new laws. So it makes our life easier because we just have to make changes if there is any non-compliance. We don't really have to go to the labor authorities or the appropriate forums to have it changed.
Thank you so much, Devika. It was a very informational session.
Thank you.